All right, we are going on air. And Pat, when you see yourself, go ahead.
Good morning, I'm Pat Morrison at the Los Angeles Times. 49 years and 5 months ago, the United States Supreme Court told American women that they have a constitutional right, within certain limits, a constitutional right to abortion. Now, 2 generations and a very different court later, that court has undone that decision. We will see the consequences for years to come, and we're going to be talking about that throughout the day with our experts, reporters, and the insights that we have gleaned here at the Los Angeles Times from reporting on this story for a very long time. First up is a reporter who has been covering the court for a very long time, David Savage, our Supreme Court reporter, who's been doing this longer than some justices have been on the Supreme Court. David, thank you for being here.
Good to speak with you again, Pat.
It's a little hard to overestimate the impact of this decision as a judicial decision, as a social and cultural decision. From where you stand, how monumental is this?
Well, as you said, I've been doing the Supreme Court for a long time, and the biggest, most consequential, and most divisive issue, I must say, for all those years has been abortion. When I started covering the court in the mid-1980s, Roe versus Wade was under attack. The Reagan administration was trying to overturn it. The court upheld it in a sort of divided opinion in 1992. And to tell you the truth, Pat, I thought, yes, this is a great controversy. People have strong views, but over time, it will sort of fade away. The right to abortion will be accepted. A majority of Americans have opposed overturning Roe versus Wade. The polls suggest they're have divided or nuanced opinions about abortion. But to tell you the truth, I always thought this is a great controversy, but someday it will subside. The country will accept the decision. And it never really happened, particularly on the Republican right. And you know the history of the last couple of years. The Donald Trump election, he ended up putting on 3 new justices, and they were all staunch opponents of Roe versus Wade. That is what he promised. And Mr. Trump didn't keep all of his promises, but that's one where you could say he did. And lo and behold, in a couple of years, we went from Roe being settled law to being overturned.
David, you'll forgive me, we've been losing your sound. You've been going in and out, so we'll try to get it back. Let's see if we can hear you again. Are you with us?
So you said that I just thought that we would never actually get to this day that Roe would be flatly overturned, but that's where we are.
David, I'm hoping that everyone is hearing you. On what basis did the opinion, which I believe was written by Justice Clarence Thomas, vitiate this ruling and say what constitutional right that the first court saw was obvious, did this court say is not present here, that undercuts the right to an abortion?
Well, Roe back in 1973 was one of those decisions that I think a lot of people thought it was the right step for the court to do, but it was not so obvious where the constitutional right came from. The 14th Amendment just says no state may deprive any person of life, liberty, or property without due process of law. And in the past, in several different areas, the court said liberty is something like the right of parents to raise their children, for example. Most people would say, oh, sure, the government can't take away their children and raise them. So there was this sort of understood right of privacy, and the court in 1973, do you know there was an interesting court, because I've had a chance to read a lot more, but I knew something about it. The 2 Nixon appointees who turned out to be crucial, Lewis Powell was a moderate Republican, but it turned out he'd worked in a law firm, and one of the young men, a distraught young man, came to him, and his girlfriend had died of a botched abortion. So no one would have known that in 1971, but Lewis Powell, the sort of moderate Republican, was somebody who believed in legal abortion. Harry Blackmun was the same way. they were all men. Those men and their wives and everybody grew up in a generation where they knew of stories of women dying of abortions, and they came on believing the abortion laws were wrong, needed to be reformed, and they basically said, we're going to say this is a part of the privacy or liberty of a woman to make this choice. It made sense to them at the time because of what they had seen and experienced. It was a 7-2 decision. As you know, the history that went on, it became a very controversial political. The Republican Party became part of the right to life movement. It was a very big part of the Republican base. And so we've had 50 years of continuing controversy. But early on, they thought this is a basic type of privacy and liberty that the government shouldn't dictate, and that women should get to make their own decisions. That was their understanding of the right at that time.
David, of course, the backdrop to this is that before the Supreme Court ruled, California legalized abortion under Governor Ronald Reagan. New York had legalized abortion. So the movement was in that direction. But that was those states, and it still stood to come to the court to see whether it would withstand the constitutional test that we're now seeing in this decision. Among the questions that are being asked now is whether or not other rights that are being based in these same privacy rights, these imputed privacy rights, are also on the chopping block. For example, the foundational Griswold versus Connecticut, 1964, which established married couples and a right to privacy when it comes to contraception. That was later expanded to everyone. Obergefell to same-sex marriage and other rights that have flowed from this particular interpretation. Is that, in anything that you read in today's decision, is that also up for grabs?
I've read contradictory things in today's decision. I just filed a sort of update for the story on our website. Clarence Thomas wrote a concurring opinion that basically said, this is only about abortion today, but in the future, we should go back and reconsider and overturn all these other precedents that involved rights that were not spelled out in the Constitution. He mentioned same-sex marriage as one of them, and contraceptives. Brett Kavanaugh wrote a separate concurring opinion to say just the opposite, that nothing in this case threatens those, and it's not going to be threatened. And I think Kavanaugh has a better sense of sort of politics and where the Republic, same-sex marriage is, there's 70-some% of the country are strongly supportive of gay marriage. So I think I find it a little bit hard to believe even in the Republican states there'll be any movement on that. But I guess the honest answer to your question is, Pat, we don't know. Thomas is a really conservative guy and will push this, but I thought it's interesting that his opinion raising this issue spoke for himself alone. Gorsuch didn't join it, Barrett didn't join it, and so Sam Alito didn't join it. So it's only so far Clarence Thomas wants to go back and try to push this even further.
You mentioned Justice Alito. It was his draft opinion that was leaked a few months ago, I believe it was in May, that started a lot of the reaction that we're seeing the consequences of already. Did what you see today in the decision vary very much from that leaked decision?
No, and in fact, if it varied at all, I haven't spotted it yet. He does have some paragraphs that respond to the dissent, so that's obviously new. But the opening paragraphs and basically the argument he makes, which is that there was never a right to abortion written into the Constitution. Was not part of the history in the 19th century. In the 19th century, at the time of the 14th Amendment, 3/4 of the states banned abortion. How could the court now say it's a fundamental right? All those things he said in that draft we read earlier, and they're in this opinion. So I would say if you or others have read the draft opinion, you pretty much know what's in today's opinion, because it looks very much the same.
David, there was a poll by Gallup just the other day that said that only 25% of Americans, this is before the Roe decision was released, only 25% of Americans have full confidence in the Supreme Court. Does this even figure in the court's radar at all, that in order to be an effective branch of government, the court has to be credible, has to have support, if not of specific decisions, then at least standing with the American public?
Well, once again, I'm going to give you two answers, which is that I think Chief Justice Roberts cares about that. Some of the others, Justice Kagan, but the conservatives don't. What's different now with the Supreme Court is what's different now, you know, as well as I do, with the House and Senate and Republican Party. That is, there are 5 conservative justices who really care about, in effect, the Republican base, the sort of conservative view in the country. And among conservatives, Roe has always been suspect, and the right to bear arms is a big on the right. From their point of view, they're doing what they think the law requires, and the conservative Republican base would agree with them. The fact that you could take a national poll and say many people don't, and they tend to be independents and Democrats, I don't think that bothers them at all.
We have heard of courts of the 1960s being called expansionist courts, especially as regards civil rights decisions. I'm wondering whether we're entering an era where a court will be called the restrictionist court, because it's been pointed out several times this morning, this is the first time in memory that the court has taken away a civil right, a constitutional right, that it has already granted.
I don't know of a parallel to this, Pat. There have been other cases where they've sort of trimmed rights on the margin, but to flat out overturn an individual constitutional right, I don't think anything has happened quite like that. So that is a big deal, and it is interesting that it follows the day after the gun decision. So on the one hand, the conservative court is willing to strike down or narrow the ability of blue states and other states to regulate guns, but they're going to free the conservative red states to essentially ban all abortion. So sort of that's where we are.
In the 50s and 60s, states' rights came down to mean the rights of states to restrict the rights of African Americans to movement, to voting, to other activities. And now states' rights has taken on a little different color, maybe a blue color, when it comes to states' rights on matters like abortion. We saw it crystallize this morning, perhaps, the fact that we will have 50 battles now instead of 1, and the fact that Greg Abbott, the governor of Texas, sent state employees home, gave state employees a holiday to celebrate the overturning of Roe versus Wade. Whereas the governor of California, Gavin Newsom, has said that he will support the legislature in its efforts to make abortion a constitutional right in California and to extend and expand services insofar as is possible. So this isn't the end of this. We may have 50 more fights on our hands in the courts.
I think that's right, Pat. To state the same thing in a slightly different words, I think we're heading into one of those, abortion's going to be a red state, blue state map of the country. That is, abortion will be legal in the blue states in the East Coast, the Northeast, California and the West Coast, Illinois and a few others in between, and then illegal in most of the red states in between. So it'll be very much, that's the way the gay marriage debate was going until the Supreme Court intervened. It was also the way the death penalty developed after the 1970s when the court stepped back. The death penalty sort of faded away in the Northeast and eventually in the other blue states, and Texas and Oklahoma are still using the death penalty. And so I think we're going to have a red state, blue state map on abortion for at least the next couple of years.
The greatest cultural social change perhaps of the 20th century as far as the Constitution is concerned was the Volstead Act, the prohibition on alcohol. And that, to many historians, created a criminal class where there was none before. Well, people who had enjoyed a drink before and continued to enjoy a drink in spite of the law banning alcohol under most circumstances. And the suspicion is that the same thing is going to happen here, that women are still going to get abortions. They will just be illegal abortions, and they will therefore be criminalized. Is this at all on the horizon?
I think it's a wonderfully interesting example, and like all, I don't know, but I think it's possible. That is, as you said, the prohibition was something that the people who were in favor of it thought that they were reforming and cleaning up the country or whatever. And instead, they set off a crime wave and excessive alcohol. It turned out to be exactly almost the opposite of what they thought they were achieving. So this will be very interesting and perhaps tragic to see how it plays out. Is that, as I mentioned earlier, the generation that went on the court and it was on the court in the 1970s had grown up knowing of young women dying of botched. They knew how awful that was and how it maybe changed. Maybe we're going to have to learn that lesson all over again.
I know that you don't cover Congress, but in some future Congress, perhaps that Congress will legislate a right to abortion for American women again. What would be the court, the judicial implications of that? What kind of hoops would that kind of law have to go through in order to meet the standard that this court has set? Or is there any kind of law that could meet that standard?
I think that's a legal question that's unclear what the result is, but as your question, the political part's the bigger thing. Because of the filibuster rule in the Senate, essentially, the Democrats would have to take control of the Senate, hold the House, hold the White House, and then have 60 votes. So it seems like at the moment that it's one of those things there'll be a lot of support for, but not 60 votes. Then there'd be a legal question about whether the Congress can pass some national legislation as a type of civil right or as a type of regulation of commerce, because you're dealing with doctors and businesses. So it would be challenged, and I can't tell you what this court would do with it, but it would be a really big and important step if Congress were able to get a majority to stand behind a right to abortion. And who knows? I mean, there's a possibility that this decision and the fallout from it down the road will create a momentum for a national law on the right to abortion.
There is a dissonance, as you pointed out, that only yesterday the court expanded the rights of gun owners, of people with guns, to carry those guns in virtually any circumstances in public without the need to prove that they need to, without the need for a permit. And this is kind of a 180, a shift from that. Is there an intellectual consistency within this court that you see in those two decisions?
Well, it certainly does. One case they're striking down state laws, and one they're freeing states to make decisions. I think it's a matter of, I think what they would say is, look at the Constitution and read it, and it's not clear at all there is a right to abortion, but the Second Amendment does refer to keep and bear arms, the right of the people to keep and bear arms. So from their point of view, they are upholding or enforcing what the Constitution, in their view, actually says. It doesn't allow tight restrictions on an individual having a gun, but it does allow, it doesn't say anything about abortion. Therefore, Texas wants to ban abortion. That's the question for Texas.
Is that the unenumerated rights that devolve upon the states part of the Constitution?
Yes, that's right. There's no enumerated right there's a right to free speech or, a right to keep and bear arms. There is no spelled out enumerated right to abortion. And yes, for many years, that's been this conservative talking point. The court should not create unenumerated, in other words, rights that are not spelled out in the Constitution.
You'd have to think of the unintended consequences then of being that strict an interpretation of the Constitution. How does it extend to cell phones, which are not mentioned in the Constitution? If you base that on an imputed privacy right, where does that right stop and start?
Well, the cell phone, there's a lot of confusion. There's a lot of complications involving cell phones. But the court had a decision a couple of years ago that said police can't just take somebody's cell phone and download it. And they did it based on the Fourth Amendment, unreasonable searches and seizures. The idea was that your cell phone is almost like your what in a previous century would have been a diary or your papers at home, and that the police shouldn't be able to leaf through them without a search warrant. And they said, same goes for cell. You have a right to privacy in your cell phone because an official wants to look in. That's an unreasonable search absent a search warrant.
It even gets down to minutia like whether you need a search warrant if your car has a hatchback versus having a trunk. And yes, you would need one perhaps for a trunk without some kind of probable cause. So the court is threading a moving needle on all of these modernities, and you just wonder how it's able to maintain some consistency, or whether that's even a concern.
I find this is still a new court. And Amy Barrett's only been there since November of 2020. This is her first full real term, and they seem bold and confident. And as I say, not too much concerned about what the general public reaction. I think it's going to be very interesting for the next couple of years where they go. The Supreme Court gets to decide the questions it wants to decide. And there's a lot of conservative groups, conservative states that are going to appealing issues up to them. And this group seems inclined to grant. Some of them are easy to say. Religion is almost always a winner in this court. Conservative Christians on also. There's a case still pending for next week on the coach who wanted to pray on the 50-yard line and drew big crowds of students. The school thought that was disruptive. I think the court's going to say, no, that's just private, personal prayer. It's protected as free speech. There's going to be a lot of these conservative cause celeb cases that come up to the court, and it's going to be an interesting time.
And some of them will probably come back as an individual test of the court's rulings. I'm thinking, for example, of the ruling that taxpayer money can be used for vouchers for schools that are religious schools. What happens if that religious school is wicked and may not conform to some of the views of the local community?
That's an interesting point, Pat, and I don't know what'll happen, whether there'll be some sort of screening or some sort of pulling back. But basically, the court's view, the John Roberts rule, you can't discriminate against religion, and if the government's giving money for something, they can't exclude religion. And that's another one of those big propositions that you sort of wonder, where is this going to go, and is it going to cause some upset when there are religions that some people are not too fond of or question. So they've opened the door to that, and we don't know how that's going to play out, or how it's going to, what controversy it's going to cause.
I wonder whether in this ruling today the justices have a real comprehension about the on-the-ground effect of this ruling on the lives of young women who for 50 years have been able to plan their futures based on the option of a Roe versus Wade, on the financial burden of young women who will have to travel to other states, on perhaps the deadly consequences of self-induced abortions for some of these young women, or whether they're simply ruling on the purity of the Constitution, whatever the consequences that the states find that they'll have to grapple with.
Well, the first is that they are ruling on the Constitution. The second is Pat, is that these are the five justices in the majority grew up and are essentially Catholics, and they, think abortion is immoral. Amy Barrett said that in the years ago when she was a Notre Dame law professor. Brett Kavanaugh said a little of that in his opinion today. I think they know that this is a problem, and young women may have a problem, but they have a very strong view that abortion is something that many people think is immoral, and that the state may choose to restrict it or prohibit it. And
But the U.S. Constitution,
I don't think they're too concerned
law.
about the immediate impact of what it's going to mean, because they stopped they allowed a Texas law last year that shut down abortions after 6 weeks, and they didn't seem to bat an eye at that. They were willing to hold that. So I think they're willing to allow a lot of restrictions on abortion, and it will not bother them.
So, David, I know you have to get back to your writing, but there is one question as we back up historically several months, even a couple of years from this ruling, and that's about what happened at the confirmation hearings for the two most recent justices, certainly Kavanaugh and Barrett. And each of them affirmed that, maybe threading the needle a little carefully, that Roe v. Wade was a settled precedent, an established precedent, and now at the first big opportunity, those two in particular vote to overturn it.
I think Kavanaugh is the one who looks particularly bad in this. I remember Barrett dancing around that question a little better than he did. But yes, he said several things. It was a precedent, been a precedent overturn. That sure seemed to me like you could say that's a truthful statement, or that was, or a deceptive statement. That is, it was a true statement that Roe was a precedent and it was a settled precedent. What he would not say, and wasn't pushed to say, okay, it's a settled precedent. What will you do? And would you overturn that settled precedent? And then he could say, like all the justices, oh, I can't tell you what I'm going to do when I'm on the court, but I want you to understand it's a settled precedent, and I'll think hard about it. So he sort of told them something that was true. Roe's a settled precedent, but it seemed then and now rather deceptive.
David Savage has been covering the U.S. Supreme Court for longer than several of the justices have been on the Supreme Court. We'll let him get back to writing. You can read his work in the Los Angeles Times, LAtimes.com. And we'll be back in about a half an hour with more Times reporters analyzing the impact of this precedent-setting or precedent-undoing decision by the U.S. Supreme Court, overturning almost a 50-year precedent of the Roe versus Wade decision as a constitutional right. You can read our coverage at LAtimes.com. You can follow us on Twitter, and we will be back with more of it in about a half an hour. And we look forward to being joined by you and for you to hear from our experts as they weigh in on the consequences of this epical decision by the United States Supreme Court.